Welcome back to another episode of Adam's Everything EV. I am here with Carl from Hagens Berman. Carl, thank you so much for taking this time out to discuss Fisker.
Thank you. Thank you for having me.
It's my pleasure. A lot has gone on since the last time I had a representative from Hagens Berman on here. First of all, the negotiations were January. That was the initial sit down with Chase to try to find a deal for everyone. Is that correct?
That's correct. We had a mediation and that was not successful. But then several weeks later, Chase just kind of on their own came up with a number of settlement offers for many or most of our clients. And we still had some negotiation there. The only thing that we negotiated at that point was to have Chase pay our fee so it wouldn't come out of our clients' recovery.
So was that offer a surprise? Was there any communication done, or did they just started coming in?
Not at all. It was a surprise.
Okay.
They told us how they calculated these. They said they had a third party come and calculate what they estimated a year of usage of the car. And that's how they arrived at their settlements for each person. We think that they did not correctly calculate the amount for the Fisker Ocean 1 people, and that's kind of been a lot of contention. Some of the other offers were quite good. People were getting offers for $58,000, $57,000, $60,000 that really kind of made them whole after all this. And we encourage everyone to take those offers. But I think that they've really just miscalculated. Their third party miscalculated the value of the Fisker Ocean 1s. And I think that, most people are not accepting those settlements.
Yeah, it's almost like it was the price of what the Fisker Ocean Sport was. It was like half.
Yes.
And that was a really disappointing reality because these were supposed to be exclusive, the Ocean 1, and because the company went under so early, most of them ended up being the Ocean 1. Is that
right? A good number, some, maybe half, something like that. But, the other trim levels, the Extreme and the Ultra, they were very good settlement offers. And we encourage a lot of people to take them, but we think that they just didn't calculate the Fisker Ocean 1s correctly. They're third parties that they had at the beginning, and maybe they'll reconsider that down the road, but they aren't doing it now.
So that's what we have to get to now is these arbitrations. How many do you have left?
We've got maybe about 550 settlements out of our client base of about 1,500. So
Okay.
about a third. And there are a number of our clients that they for whatever reason did not provide a settlement offer to. I think that they didn't realize they were our clients or something like that. People that were Hagens Berman clients got three options to either trade in on a Rivian to get cash back when Rivian purchased their car, or to sell it to Chase if it was inoperable and survived one of Chase's inspections to determine it was inoperable or not.
And the people that were inoperable, those are definitely being made whole, right? That was like a whole. And then because that is part of the offer, are your fees also being waived for them too?
Our fees are being paid by Chase. We negotiated a reduced fee of $5,000 per case, and Chase is paying that. So all of the settlement offers go directly to our clients, and that was actually negotiated after the amounts were determined by Chase.
Right, because this was such a surprise.
Right. But that also, it shows that those were negotiated separately. So these were the amounts Chase was going to offer, and the fact that they're paying our fee did not impact that amount.
And other than that, as far as the numbers, like you said, the Ultras and Extreme people got good offers, but these Ocean 1s. It's definitely different. Timing, though, is another thing. A lot of these vehicles don't run right. They're not operating optimally, like just to be nice for a way to say that. And so getting out is kind of just a priority for some. And I think maybe for some of those people, it was okay to get out, but I don't know if the number really worked for some others. But I really wanted to kind of try to dig into the arbitrations themselves. What does an individual arbitration process look like from a, like a high level, whatever you're allowed to tell me?
There's two arbitration services that we can use under the contract, JAMS and AAA, and we've been using JAMS. We filed maybe a little over 500 arbitrations, and I expect that we'll file the remaining ones in the next week or two. JAMS has promised that they're going to give us kind of a faster than typical procedure. But if you just were to file an individual arbitration, it would take probably 4 to 6 months.
Okay.
I don't know how the fact that there's 900 of them is going to really impact the play at jams. We'll have to see how that goes. I'm not sure that anyone's really done this at jams like this, had 900 individual arbitrations, and they can't be brought as a class action. They can't be brought as a group action under the terms of the promissory note. So we're stuck having to do them individually.
Yeah, and that's where your expertise really comes in. A lot of car owners don't understand that this is kind of how every single situation of this type would work. Pretty much everyone's under an arbitration agreement that owns a car. Is that right?
In this case, because we're suing Chase rather than Fisker, then they are subject to an arbitration agreement. And this is, I'm really unaware of any case being brought like this before. I mean, car companies really just don't disappear like this.
So basically, everybody that buys a car is signing up for an arbitration agreement, whether they know it or not. But this weird, extremely fast bankruptcy, but they still delivered cars, is the situation that's making it unique.
It is. And the defendant being Chase. I'm really unaware of anyone bringing a big group of cases like this against the bank when a car company went under. And it really is, it's pretty unusual. And the fact that it's a fairly novel legal theory against the biggest bank in the world adds all kinds of complexity to it.
Right, and you're referring to that's the holder rule, which is the holder in due course rule, which needs to be identified as somebody who participated in the process of loaning people money and would take responsibility in replacement for a company that's no longer there. Is that a basic understanding?
That's right. That's correct.
Okay, so let's say I'm an owner and I know that my arbitration is coming. I'm working with you guys. I have a Fisker Ocean, or maybe I've sold it. That's my situation, is I've already sold mine. What do I need to do to get prepared, and how are these decisions made? Because they are made on an individual basis. Is that right?
That's right. We file these cases. We filed maybe 20 cases already, just kind of as test cases. And the first of them were coming up. The hearings were going to be in May, but they were among the settling parties. I think the first one that actually is going to go to arbitration is going to be in July.
What does a win look like? If you are to, is it a black and white, like you lose, you win, and there's nothing in between?
No, the arbitrator, each case gets assigned to one specific arbitrator, and at jams, they're typically retired judges. And it's basically the arbitrator has a lot of discretion and can come down on one side, on the other side, or somewhere in the middle. It'll be completely at the discretion of the arbitrator. We think that these cases are pretty strong. There's some overlying facts that apply to everybody. Everybody that had a Fisker, their value of their car diminished rapidly because of the bankruptcy, because of the recalls and all these other things. And then each person has individual issues, like maybe their emergency brake pops on going down the highway or something like that. So when we go to the arbitrations, we're going to bring both arguments, so that just that overall systemically these cars lost tremendous amounts of value because of defects, and then also any specific issues that people have will bring to the arbitrator as well. So these cases are filed, and we'll contact our clients as soon as a arbitrator is set and a hearing date is set, and we'll make sure that we have all of their documents, all of their evidence, and we'll go through the process with them and explain to them what we're going to need from them. They'll have to attend the hearing, or likely in person is better, but you can do it by Zoom if it's in a convenient location.
Okay.
And we have retained experts. I really don't want to get into them, but we've our litigation strategies, but we've retained the appropriate experts, and we're preparing all these cases. And there'll be some element of all these cases being the same, but then there'll be, on top of that, there'll be individual issues for each person.
Okay, so it's complex, complicated, thorough, and evidence-based, and then the judge can land anywhere from partial settlements or partial loan amount, whole loan amount. That was definitely a question I had. And then you said $5,000 earlier. That is a negotiated down fee for you guys, because this is a lot of work, right? And
that's
so
right, because we hadn't really done a whole lot of work up and for each individual case. And we wanted to negotiate an amount that wouldn't come out of our client's proposed settlement. So that was the number we came to with the assistance of the mediator with Chase.
Let's do a scenario. I've got a Fisker Ocean 1. It has less than 10,000 miles on it. I haven't driven it much because I don't trust it. And then we go to our arbitration hearing. The judge makes a decision. How would you explain this process to an owner?
We're bringing claims under both lemon law and warranty claims.
Okay.
And some of it will depend on what state you're in. But say, like a state that has favorable laws like California, we'll bring them under the lemon laws. And part of the lemon law is that you can recover attorney's fees. So, I mean, if we have to bring these cases to arbitration, we need to charge our typical 30% attorney's fee. But we can recover that under the law in many or most states under the lemon laws.
Okay.
So that is what we would try to do. The one issue here is that the holder rule that you talked about, on one hand, it allows us to bring claims and have liability like in Chase. But on the other hand, it limits Chase's liability to the amount that they loaned the person. So if someone made a $50,000 down payment or $25,000 down payment, that money's really lost, and we can't recover that from Chase.
Okay. Someone who would be taking this settlement in favor, let's say had an Ocean and got that 36,000 and change offer that most of them got. If they put a big amount down, that's not a bad deal at all, right? Because we have the time. And on top of that, there's not going to be that total loan amount. However, like you said, though, and this was something I really need to clarify because a lot of people had questions about this. A win is not 100% of your loan necessarily. Let's say you don't have a bad experience with your Ocean, but you have gone through this and you've put a lot of miles on it. Like, what's the situation where the judge lands in the middle, I guess, is probably the best way for me to phrase my question.
We think one of the problems is that's kind of systemically these Oceans were sold, the Ocean ones were sold for $70,000, say, and if the truth had been known about all these defects, they'd have been worth, $40,000, say. So there's, $30,000 damage that everybody incurred, and we think that that's going to be one of the methods of recovery. Not everybody's going to. The lemon laws are designed to replace your car. There are some people that want to keep their car, but they suffered this loss, and we have experts that are going to be able to testify as to what the value of the Ocean ones would have been had all the truth been there.
So the evidence is going to play a role, right? And the evidence that we all know that we do have is that in April of, let's say, I don't remember, was 23. By April of 23, the Oceans were starting to be delivered, and then in April of 24, they had visibly, in an advertised capacity, still as an existing company, reduced the price by half or pretty close to half. But so that's kind of your base case as far as what you can drop on this judge and kind of work towards getting for every client. And then the rest is going to depend on evidence and situation and whatever their circumstances are. Is that kind of...
Yeah, the lemon laws require you to make some showings about how either there were defects in the car that you attempted to get fixed or that the value of the car declined precipitously.
Okay.
So we think that most of the claims will fit under lemon laws, but again, that's state by state. But even if the lemon laws won't apply, there'll be breach of warranty claims.
Is there any benefit to not contacting you and trying to get a settlement here?
Well, I don't think so. No, I mean, I think, just in this first wave of settlements, you can see that our clients had 3 different options, and the people that weren't represented had one option, just to trade into Fisker, and many people didn't want to do that. And in fact, because of that and dichotomy, we've had a number of people sign up with us.
Do you think Chase will make another round of offers?
Well, I think it would make sense for them if we do these arbitrations and win, the first 10 or 15 of them. I think it would make sense for them to want to settle these out, but I really can't say what the biggest bank in the world will do.
Well, it's May of 2025, basically, right now. In the event, worst case scenario, that, Chase is just going to try to hold on and, individually bang each one of these out, how long do you think these, your current caseload is going to take as far as, what you've seen so far?
Yeah, a lot of it will depend on how fast things can go through jams and through the arbitrator. We're going to devote a lot of resources to this, and I think we could try to knock these out by the end of the year, but it's not going to be a 1 or 2 month process. If it goes to arbitration, it's going to be 6 to 8 months process.
Is there a priority that you are filing these in, maybe by state or by trim or by experience, amount of evidence? Is there any, or is it just you just got to go one at a time and put them through?
We just put them through, and and some of it'll depend on how quickly the individual arbitrators are appointed, and then how fast that arbitrator can move. Some of them have very heavy schedules, and we can't get a hearing date for months and months and months. And some of them have much lighter schedules, and we can proceed faster.
Best way to reach out to you guys?
Email fisker@hbsslaw.com.
Final thoughts and just kind of a summary. You're working on the arbitrations. You're starting to put them through. You'll have most of them filed, sounds like, by the middle of this year. And then you'll try to bang them out by the end of the year. And a settlement could be anything from the entire amount of your loan all the way down to whatever the base case is. Is that?
That's correct. So we'll have these arbitrations all filed in the next few weeks, but they might not actually get hearing dates until later in the year.
Do you see anybody losing? Just like an absolute no, walk away? What's your likelihood there? Can we DraftKings that? I'm just kidding.
No, I don't think so, because I think everybody lost a tremendous amount of value. Whatever their purchase price was much higher than the cars were worth after the bankruptcy and after all of the recalls and everything like that. And I think that that's going to apply to everybody. Now, some people might have bigger problems with their cars and be subject to the Lemon Law requirement that the Chase repurchase the car, and some people might not want the car repurchased. So there's going to be kind of a whole spectrum of damages, but I think everybody's going to have at least a minimum level.
Sure. I can't thank you enough for taking the time. I think this will answer a lot of questions for folks, and I think people will have a better understanding of how this will work. Is there anything else you'd like to add?
There's one thing. I know that there's been a lot of discussion on social media about why Chase was requiring this IRS Form W-9 to be part of the settlement. And a lot of people were speculating that Chase was going to issue a 1099-C, a cancellation of debt form, which could have had bad tax consequences for our clients. And after much back and forth, they finally disclosed that, in fact, they don't plan to issue 1099-C cancellation of debt forms as part of these transactions. If as part of the transaction you still owe money to Chase and you don't pay that money, then you could be subject to a 1099-C. But as far as just related to the transaction itself, they're not going to issue a 1099-C.
So because this is a settlement, even though you're trading in for something else, technically right, what they're doing with that Rivian offer was a settlement that yes, there could be a tax implication, and you're saying that after conversations with Chase that's not the case.
That's right. It is a sale to Rivian rather than Chase just canceling your debt. And so that's why it would not be appropriate. And we had a lot of discussions with them, and they finally agreed and that they would not issue a 1099-C in that circumstance.
Carl, your time is much appreciated. I invite anyone who has comments to let us know in the comments below, and I will direct any other inquiries onto you guys. Thank you so much again for being on the channel.
Thank you, and thank you for everything you do to get information out there. Appreciate it.
Hey, smash the like button.
Thank you.